If you've just been served with divorce papers in California, a clock is already running. This form is how you answer it. This is Form FL-120, the response. It's the document you file after being served with a petition, and it comes with its own strict deadline. Let's walk through it section by section. FL-120 is filed by the spouse or domestic partner who did not start the case. That person is called the respondent. The case might be a dissolution, a legal separation, or a nullity, and it was opened when the other spouse, the petitioner, filed Form FL-100. FL-120 mirrors that form closely. It asks about the same case facts, and it gives you the same chance to tell the court what you're asking for. Filing a response doesn't mean you're contesting the divorce itself. A lot of respondents agree the marriage should end, and they use FL-120 just to confirm the facts and make sure their own requests for custody, support, and property are part of the record. Now, the most important fact about this entire form. You generally have 30 days from the date you were served, not the date the case was filed, to file your response. If you miss that window and haven't filed anything, the petitioner can ask the court for a default. In a default, the judgment is generally based only on what the petitioner asked for, with no input from you on custody, support, or how property is divided. A default doesn't necessarily mean you lose your voice forever, but undoing one once it's entered generally requires a separate, harder court request. It's far simpler to file on time. If you're close to or past the deadline, treat it as urgent and contact your county superior court self-help center right away. Let's go through what you'll actually fill in. Section 1 is Case Information and Parties. Enter the county, the case number already assigned to the petition, and the names of the petitioner and respondent exactly as they appear on the original filing. Use full legal names matching the petition, even if you go by something else day to day. Section 2 asks you to confirm the type of case the petitioner requested, dissolution, legal separation, or nullity, and lets you state whether you agree or want something different. It happens more than you'd think. A petitioner requests dissolution while a respondent asks for legal separation instead, or the other way around. Section 3 covers statistical facts. This is where you confirm or contest the petitioner's stated date of marriage and date of separation. You don't have to accept their dates automatically. If you believe the actual separation date is different, state your own, since it can affect how property and debts get divided. Section 4 is residency. If dissolution is requested, you'll address whether California's residency requirements, generally 6 months in the state and 3 months in the filing county, have been met. Legal separation requests skip this section entirely. Section 5 is legal grounds. Like FL-100, this generally points to irreconcilable differences, California's no-fault ground. You're not required to prove wrongdoing, and the form doesn't ask for details about why the marriage ended. Section 6 is the one that matters most for protecting your interests, your own requests for relief. This is where you state what you're asking the court to grant, independent of what the petitioner requested. That includes child custody and visitation if you have minor children together, child support, either to pay or to receive, spousal support, property and debt division, including any separate property claims, and attorney's fees if applicable. Be thorough here. In many cases, the court can't grant relief you never asked for, especially if the case moves forward without full agreement between you and your spouse. Leaving this section incomplete can limit what you're able to receive later. The mistakes that show up most often with FL-120, missing the 30-day window, not filing a response at all, which can lead to a default based only on the petition, failing to state your own requests so the court has nothing from you to consider, accepting the petitioner's separation date without checking whether it's accurate, using a nickname instead of your full legal name, and filing without confirming the case number and county match the original petition exactly. Once you file, you're not finished. You'll generally need to serve a copy of your response on the petitioner. Both spouses remain bound by the automatic temporary restraining orders that took effect when the petitioner was served. California's mandatory 6-month waiting period, which started when the petitioner served you, keeps running regardless of when you file your response, and both spouses still need to complete financial disclosures before the case can move toward judgment. Filing FL-120 generally costs $435 to $450 depending on the county, similar to what the petitioner paid to file FL-100. If you can't afford that, you can request a fee waiver by filing Form FW001 alongside your response. If you're staring down that 30-day deadline and don't want to miss anything, that's exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and fills out your FL-120 for you, free during beta. Virdix is a document preparation service, not a law firm, so this is not legal advice, but it can help make sure your response is complete and on time.